riječ delegaciji. Čućemo njihove odgovore na pitanja koje su naše kolege upravo postavile. Postoji možda neki problem sa...
This is the committee, Human Rights Committee, under the International Covenant on Civil and Political Rights. The English is working, okay. Is the?
I'm sorry, I'm listening. I hear Montenegro on number 2, which should be English.
Montenegro is coming through on 2, and English should be coming through on 2, and Montenegrin should be coming on something else. Still not working. 1, 2, 3, 4. Now it's working.
No, is it working? What number is Montenegro? 6. Is it working? 6. Okay.
Montenegrin is coming through on 6, is it? Yes, it is. Okay. And is English coming through on 2?
This is just testing the English.
Be coming through. So now we have the infrastructure in place. I'll invite the distinguished head of the delegation, the Deputy Minister, to begin the replies, and it's up to her, as I think she knows, to assign the replies as she wishes or to take them all herself. And again, over to you, Madam Deputy Minister. You have the floor.
Hvala. We agreed, the members of the delegation, that based on your request to these challenging questions, we'll respond in grouping them because each of the member of the delegation recognized their own area. So I'd like to start and then kindly ask the gentleman, Mr. Radakojevic, who is the judge of the Supreme Court, to start with answering the first part of the questions. Mr. Chairman, Your Excellencies. So, our head of the mission introduced me, but once again, my name is Radule Kojevic, judge of the Supreme Court. It is my pleasure to be here, and I will try, together with my colleagues, respond to your questions if we are able to do so. So I would like to start with the responses concerning your first question in relation to the information on the cases when it comes to the direct application of the covenant, International Covenant on Civic and Political Rights. In Montenegrin courts from January 1st, 2012 up until 15th September of 2014, judges in Montenegro in 20 cases refer directly to the Covenant on Civic and Political Rights. So there was a question why there was not a higher number of cases where the judges referred to the Covenant on Civil and Political Rights. Our state became independent in May 2006, and since then we started renovating a large number of laws. All of those laws went through the control of the experts of the Council of Europe, and our country and our legislation has done everything they could that in our laws we incorporate the provisions and standards of the international treaties, conventions, which were ratified by our state. In all of our laws, we have built in the provisions which were ratified by our state. This is why we do not have that many cases where we could refer directly to the provisions of the covenant. We, in front of us, have the exact number of these cases and the exact serial number of the case. If you need that identification number, and we can provide this to you when it comes to the Constitutional Court. Up until in our practice, depending on the proceedings, Constitutional Court regularly and directly refer to the provisions of the covenant and the practice of the Constitutional Court was given in the Annex 1 when it comes to the application of the International Covenant in regular courts. They usually applied it in basic courts in Podgorica, and the basic court in Podgorica is the largest court with that competency in the state of Montenegro. When it comes to the administrative court, we do not have any court decisions where they refer directly to the provisions of the International Covenant, and we stated this in our initial report. When it comes to the training of office holders, judges and prosecutors, I have to say that the Center for Education, Judicial Training Center, has two different trainings. This is continued and initial training. Continued education refers to judges and prosecutors, and it is organized in continuity each year, but when it comes to initial education, it encompasses our younger colleagues, which have passed the bar, and they work in the prosecutor's office, courts, as lawyers, and in the police department and other state bodies, and we organize training for them regularly. When it comes to the funds for organizing these trainings, whether this is initial or continuous education, usually we hire experts from Europe and around the world, and it is done usually with the assistance of donors and or with the financial assistance of the Judicial Training Center, which is financed by our state. Action plan for the Chapter 23 for the accession to the EU envisages financial and administrative strengthening of the Judicial Training Center, and this will enable them to organize more trainings on human rights and freedoms. When we speak about training on human rights and freedoms, this was envisaged through regular annual plan of education made by special planning board at the level of which is part of the Judicial Training Center. The next question was, just a second please. Free legal aid. This is question number 13. In all of the basic courts in Montenegro, we organized a service for providing free legal aid. So not to lose time concerning this issue, in front of me I have the data for 2012, 2013 and 2014 for each of the courts, how many requests for receiving free legal aid were made and from which groups, especially vulnerable groups, how many of them were recognized as valid and how many were recognized as not valid, and the time frame for decision making. So without losing time, I have this printed out in front of me. If you need it, I have it. I can provide it to anybody who might be interested. So when it comes to the reform of the Montenegrin judiciary, I would like to say that in the last 5 or 6 years we did a huge step forward in solving of backlog cases, and in our report we precisely stated what is the number of these cases, and at the end of 2013 in all of the Montenegrin courts we have only 4,251 cases which are older than 3 years out of all of the court cases, and which are older, so which come from 2010 and older, and in August 1st of this year we had only 3,815 cases older than 3 years of all types, and all of these cases, according to our annual program for backlog cases, have the priority when it comes to the work of the courts. Some of the cases do last longer or are returned to the courts several times, but this is a really small number of cases, and according to the law, truly I can state which these cases are. So there's only 2 or 3 of them which are very complex and very difficult, and the reason why these cases were sent back to the courts is because we wanted to fund our work based on the law and rule of law, and not because of other reasons. And when it comes to war crimes, I have to say that all of these cases have an international element related to them, and we needed to get the evidence from the other states, and we couldn't do this within a month or a year, because it did not depend only on our courts and our state, but also from the goodwill of other bodies and other states. And we tried to do this in the shortest time frame possible. In this sense, our state has organized the courts and all of the technical and administrative and other forms of support so that these cases can be completed as soon as possible. When it comes to the war crimes, I have to say that truly some of the cases have been completed, closed. Not only 3. First of all, Morin has been finalized legally, and we have brought the final court decision. Also, when it comes to deportation of Muslims, we have released 9 people due to the illegal transport of Muslims. Also, Bukovic was completed. Then Kaluđerskila's case, we have the first instance made decision, but the appeal procedure is ongoing. And also Štrpci, this is also being completed because the accused person received the maximal penalty according to our law, and this is 15 years. Then the killing of Murder family Klapuch in 1996 has been completed, and several persons were accused, and they were found guilty and indicted and was sent to prison. When it comes to reparations and damages, compensation for damages of civilians which were hurt during the war or their families, in front of me I have the complete set of data about the number of court cases and the decisions. And if you allow me, I would like to read this so that you can see what we did. Montenegrin courts have 11 final court decisions where we agreed to compensate the damages to the victims of war crimes, 217,000 million euros, and I didn't catch the amount of paid in dinars. And basic court in Podgorica awarded 172,000 euros in 7 cases for war crimes. Concerning the case Morin, 1 case of illegal of kidnapping of people in Štrpci, 1 case with Muslim people which were taken from the territory of Montenegro and sent and deported to Bosnia, to Republic of Srpska. And basic court in Bielopolja, we had a final court decision in 2 cases, and in both cases it referred to the hijacking of people from the train in Štrpci, and in 1 case it was 45,000 euros of damages, and in other case 4,200,000 dinars, meaning 33,000 euros approximately. In Montenegrin courts we have a settlement in 42 cases, and in these 42 cases we have awarded the amount of 4,135,000 euros, and all of these settlements were concluded in the basic court in Podgorica and referred to the cases of deportation. the cases when it was the demand was invalid. In total of 13 cases, we have had an invalid request for compensation in the basic court in Podgorica. In 12 cases, 2 cases for the case of Bukovica, 9 for case of Murino, 1 case for the case Kaluđerski Laz. Basic court in Cetinje refused the reparation demand in the case of Bukovica. In 14 court cases, they withdraw the request for compensation, and all those cases referred to the Kaluđerski Laz. In basic court in Podgorica, we have 150 court cases for war crimes. In the case of Morin camp, in 6 out of those 150, the compensation for war crimes in Kaluđerski Laz, the procedure has been paused until the previous issues are solved in the previous court proceedings. In Bilo Polje, in 1 case concerning the hijacking of people from the train in Strpši, we have the first instance court decision where we adopted the request and awarded 16,146 euros. Appeal is currently ongoing, but all of the families and victims are guaranteed compensation and reparation and access to justice, and different articles of the law on obligation relations norm the compensation from non-material and material damages in case of death, bodily harm, or damage to health. And this is defined in Article 2001, 2, 3, and 4 of the Law on Obligation Relations. When we speak about the financial independence of Montenegrin courts, the courts in Montenegro are not financially independent. Consumer unit judiciary is part of the budget of Montenegro, and it is being proposed by the government and adopted by the Parliament of Montenegro. All of the courts submit to the Judicial Council a projection of financial needs for the following budget year, and based on those projections of the courts, the Judicial Council proposes the budget for consumer unit judiciary. Based on that proposal, the Ministry of Finance proposes to the government, and the government proposes finally the budget proposal to the Parliament of Montenegro, and then the Parliament of Montenegro adopts the budget of the state. When we speak about the courts, the misdemeanor courts, just a few words. The strategy of the reform of the Montenegrin judiciary, which according to the action plan for the chapter 23 is presenting special measures in the part when it comes to the strengthening of the efficiency of judiciary, which refer to the rationalization of the judicial network. This action plan envisages changes to the legal framework and organization and competencies of misdemeanor bodies by adopting the law on courts, which shall define the organization and competencies of the courts for misdemeanor procedures. For leading the misdemeanor procedures. The current situation, when you speak about the misdemeanor courts, most of the municipalities have the bodies for misdemeanor procedures, and they are in charge of leading these misdemeanor proceedings, and they can issue fines and prison sentences up until 2 months. Concerning you can appeal against the decision of the misdemeanor bodies, and the misdemeanor commission of Montenegro decides on these appeals, and you can also appeal against the decision of the commission, because you can address the administrative court and they will discuss your demand, your appeal actually. when it comes to the law on courts, which is in the procedure of adoption, and we have a draft law already. This draft law envisages that these courts are part of the basic courts, meaning regular courts. This law is currently in Brussels for overview to the experts of the Council of Europe, and as soon as they give their opinion concerning this law, the Commission of the Ministry of Justice shall make an effort so that this law is given to the government to discussion and adoption. Okay. Now Natasha Pesic can take the floor. Natasha Pesic, Secretary of the Ministry of Justice.
Zadovoljstvo mi je da vas pozdravim. Govorit ću, odnosno
with reference to the free legal aid, I would like to add to what our judge, Mr. Radulekovic, has said. As far as I understood, you asked us who decides on the claim for the free legal aid. According to the Article 24 on the free legal aid, the ones who decides are the presidents of the basic court. If the person in question, the claimant is the foreigner, it is explicitly said that the president of the Podgorica basic court is to decide on the claim. Since Podgorica is the capital and has the court with the biggest number of cases when it comes to the first instance courts, basic courts in Montenegro. As far as I understood, you asked how long it takes to reach a decision on the claim on the free legal aid. According to the Article 42 on the free legal aid provision, it is provisioned that the president of the court has to decide within 15 days' time. As far as the procedure is concerned, this procedure has been regulated and given in more details on the rule book on the free legal aid, within which you have all the data as to what the claim has to consist of in order to have the president of the court reach a relevant decision. Since the draft proposal of the law on the changes and amendments to the law on the free legal aid has passed the procedure before Montenegrin government, you will understand the importance of adopting such a law has been recognized within the action plan for the negotiating chapter 23 and legal area, actually judicial reform strategy for this period, where in order to improve the transparency, accessibility, and to increase the trust of the public into the judiciary, one of the strategic guidelines is to develop and to strengthen this free legal aid system. The most important goals to be achieved is to enable the free legal aid even within the bailiff's procedure, the procedure before the bailiffs, and to have the victims of the family violence given the opportunity to be the priority users of this free legal aid, as well as to enable the same to the persons who have undergone as victims the trafficking in people or have been the victims of family violence. Then the basic criteria as the basis for having those rights shall be changed, as well as the criteria will be clearly given upon which a lawyer may decide not to provide the free legal aid. I believe that this has clarified this issue. Thank you very much. Thank you, Natasha. Now I will give the floor to Ms. Samardzic, Deputy Special Prosecutor for Fighting Organized Crime, Corruption, Terrorism and War Crimes. The floor, Miriam, is yours. Thank you. I work in the Supreme State Prosecutorial Office, where we deal with the cases of the organized crime and war crimes. My colleague, dear colleague from the court, has given the answer even to some questions that the prosecutorial office should have answered, but I would just love to give some additional remarks as far as the training of the prosecutors is concerned. Apart from the trainings that they pass within the education center, and especially in the past period, they have participated in a number of international trainings referring to the area of human rights. Apart from this, and we deem this important with reference to the training of prosecutors, especially referring to the issues where the children are the victims of family violence, or when it refers to the juvenile delinquency issues or cases. In every prosecutorial office, there is one prosecutor at least who deals with those cases. Every prosecutor in Montenegro dealing with the cases, including the juveniles, or the cases where a child is a victim of a violence, has passed a specific training. Apart from this, within this year and the past one, and this is a novelty, I have to say, in the prosecutorial practice, we have expert persons who support the prosecutors when it comes to such cases where the children are the victims of violence, or when we speak about the cases where the perpetrators are juveniles. With reference to the investigation, referring to the war crimes, and especially the issue raised with reference to bombing Dubrovnik, we do not have this case within Montenegrin prosecutorial office. However, a part of this case had been processed in The Hague. To that extent, which means opening new investigations, Montenegrin prosecutorial office signed agreements with the neighboring countries. We have recently signed an agreement with the prosecutorial office of Bosnia and Herzegovina on the cooperation exchange of data in order to prosecute actually new cases with reference to the war crimes. And the same agreement had been signed with the Croatian prosecutorial office. Therefore, we believe that by signing such agreements, we will enable the prompt exchange of information and therefore opening new pre-investigative and investigative procedures. Just one more remark referring to the work of the prosecutorial office, and that is that in Montenegro, the prosecutors are those who reach a resolution on detaining the accused for 48 hours, which means they are not obliged by the law to inform them as to whether they are entitled to the free legal aid or not, but they do so in practice. They do the same when it comes to the victims of trafficking in persons, in human beings, which are in most cases the witnesses. However, they are briefed and informed by the prosecutors on the opportunities provided under the law on the free legal aid provision. So that would be all on my part. Thank you. Thank you, Mira. Now, Mrs. Blanka Radošević-Marović, Deputy Minister of Human Rights with the Ministry of Human and Minority Rights. You have the floor. Thank you. First of all, let me answer the questions related to the Protector of Human Rights and Freedoms, that's to say the Ombudsman of Montenegro. And I would like to say that by adopting new changes and amendments to the law, the changes and amendments of the law on the protector of human rights and freedoms, by those changes and amendments, we have provided for the conditions to have the independence of this institution in line with the Paris principles, and that we have achieved the harmonization of it with the acquis and the other international documents. This law clearly and better positions the function, the institution of the Ombudsman, that's to say the protector of human rights and freedoms, in order to fight more successfully torture or any other misbehavior and those who perform those functions. And we have adopted the Ombudsman Plus model, where apart from the experts in various areas who are supposed to make the working body, it is possible to introduce the experts from the NGO sector and civic society. We have also harmonized and adopted new bylaws, whereby some of them should be adopted by the end of this year, which had been provisioned by this law, and we have also adopted the document of the internal organization and systematization of working posts. We are also supposed to allocate to adequate position the employees, which shall additionally improve the capacities, enhance the capacities of the Ombudsman and his function as the protector of the human rights and freedoms. We have also adopted reports on the assessment of the state of affairs and recommendations, and in line with the conditions to get the accreditation of these national institutions in order to promote and protect human rights with the International Coordinating Committee. Therefore, we have initiated this accreditation procedure in order to get the international status. And as far as the authorities of the Ombudsman as the national preventive mechanism against torture are concerned, the new changes provide for the unlimited access to the protector deputy members of the working body as well, in order to actually their access to all the documentation, all the premises, without any limitation as to the level of secrecy when it comes to the protection of the people who are in the institution of the closed type. As far as the higher financial independence is concerned, the changes and amendments significantly improve the financial position of this institution in a way that we have a norm introduced which provides for the adequate expert position, which improves their status in line with the new law on the allocation of the budgetary funds. There is a separate article introduced which enables the protector of human rights and freedoms to decide independently on employing his employees in his office and to decide on their responsibilities, salary level, and so on. And he's not obliged to get any approval from the Ministry of Finance in our case. We have also introduced the provision providing for the opportunity to have the permanent protection of the employees of the Ombudsman's office, which means the immunity from any kind of sanction or any aggravating consequences which they may suffer due to presenting their stances, their opinions or recommendations within their line of duty. Since we have had a question as to whether the new amendments adopted in July are or not available at the website, I would like to say that we have an English version posted on our website, and that by having the full insight into this document, we believe that you will have all the questions clearly answered. With reference to the functioning of this institution, there had been comments whether or not this institution has or doesn't have enough capacity to deal specifically with the discrimination issues, or what the total number of employees within this institution is, as well as within other administrative capacities. What I have been informed about is that this institution has 28 employees, which is twice more than the ministry that I represent here. And in addition, the Ombudsman currently has 4 deputies, out of whom one is in charge of protection against discrimination against minority and vulnerable groups. However, the protector, the Ombudsman, has the right to appoint as many deputies as he or she deems necessary. And by the action plan for the Chapter 23, it is provisioned to have additional jobs created in his institution for the period 2015-2016. However, as of now, he or she, as the protector of human rights and freedoms, will be fully independent in terms of employing his staff, his or her staff. And therefore, I do not believe that there is a lack of capacities anymore, because as of the end of July or the beginning of August, he or she is enabled to undertake the legal procedure by fulfilling the jobs, the posts in his or her institution without asking for any additional approvals or authorizations. The following issue referred to the gender equality, and let me say that what Mrs. Waterwall has clearly stated here is that we do have a coherent legal framework when it comes to the gender equality. Therefore, we have both the law, which stipulates explicitly what gender equality is, what it entitles, and it is said, it is provisioned that it is obligatory in all areas of public and private sector. And in addition, that the Parliament of Montenegro, the government of Montenegro, are obliged to apply gender equality principles, especially the gender balance principle. And we have adopted the activities, the action plan, in order to reach the gender equality for the period 2013-2017. And each year, annual action plans are adopted accordingly. And it is also very important to say that within this year, in March, the Parliament adopted the law on the changes and amendments to the law on the appointment and choosing the MPs, which define the obligations of the political parties in order to provide for the higher representation of women in the political life of Montenegro, which means that for the time now it is definitely obligatory, as the Article 18 provides for the better and higher representation in the decision-making posts in Montenegro, in a way that all the election lists have to say a quota of at least 30% of the candidates of the less represented sex. In this case, those are women, in a way that per every 4 candidates, according to their order in which they're presented on the list, at least 1 should be a woman. The election list which does not make such requirements will be void. And as I have said, a number of memoranda had been signed with the local municipalities of Montenegro. And we have established local action plans as well in order to reach gender equality at the local level. We have also appointed the coordinators of those activities and have those who bear those activities who are responsible for those activities at the local levels as well. As far as the legal framework is concerned, and speaking about the issues of the fighting the violence against women, we have also made significant progress within the couple of months. by having the law on the protection against family violence adopted, the relevant strategy adopted, the relevant protocol on acting in the cases of the family violence, acting by all the relevant institutions, and we have adopted the plan in order to reach gender equality and all the other legal documents and bylaws which deal with those issues. I can also say that Montenegro is a signatory of the Covenant on Eliminating All Forms of Discrimination Against Women, CEDAW, and the report on its implementation in Montenegro was submitted in 2011, whereby Montenegro was commended for having adopted several required measures in order to eliminate any form of discrimination against women, but they also asked for the additional information on the implementation and the recommendation related to this area, specifically to the violence against women. 2 years later, Montenegro, in January, to be more precise, of the current year, Montenegro forwarded the report to the relevant UN committee on the implementation of this very important recommendation. In addition to this, Montenegro is one among the first 5 countries who signed the Convention on Preventing and Fighting the Violence Against Women and Against Families, so-called Istanbul Convention, which was ratified in 2013. And the law on the protection against violence in family violence actually, which came into force in 2010, prescribed for 5 very important protection measures against family violence, which means removal from the living premises, restraining order in terms of stalking and disturbing, obligatory psychological and social treatment, and treating any addictions in terms of this, and the obligatory protection of the family members. It is very important to say that we have established a protocol on acting in such cases, and to that extent we have established multidisciplinary teams which provide continuous support to the victims of the family violence. As of the moment of having the law adopted, which means as of 2010 until now, we have had the increased number of cases reported on the family violence and violence against women, which doesn't mean that the violence itself has been increased, but it shows that the law has been applied in practice. And to draw back on the question asked by Mrs. Waterwall, referring to the implementation of all those measures there, implementation in practice and everything that had been regulated within the legal framework and provisioned for. Let me say that the fact is that when we speak about prevention measures and the implementation of the law, in any case we have a lot of things to do. What we are definitely doing are, first of all, the trainings upon the subjects on the political representation, participation of women, their economic strengthening and fighting violence against them, which are undertaken in order to sensitize the target groups, that's to say those who are obliged by the law to implement in practice these legal frameworks. Therefore, the trainings are done every year and are mostly organized by the Gender Equality Department within our ministry in cooperation with UNDP. And this is a multi-annual long-term cooperation that we have been having, and the participants are the employees in the public institutions, local governance, lawyers, office holders in the judiciary and prosecutorial offices, teachers from the primary and secondary schools, women from the rural areas, representatives of the media, and the others accordingly. To be more specific, as of January this year, we have had 6 trainings, 2 workshops, 4 seminars, 1 roundtable, and 1 1 month actually course for the women from the rural areas, aimed at enabling them to be more competitive at the labor market. Therefore, with reference to what my department is in charge of, is to sensitize the public and those who are decision makers who implement the legal framework in practice in order to sensitize the women to reach gender equality and to fight the violence. The other issue that we have received here with reference to the rights of the children, that's to say, to which extent children are aware that they can use complaint mechanisms and protection mechanisms. Let me say that within the institution of the Ombudsman, that's to say the protector of human rights and freedoms, one of the deputies of the Ombudsman is a deputy in charge of the protection of the children's rights. And since pursuant to the law on fighting and preventing discrimination, the protector of the human rights and freedoms is considered as an institutional mechanism for providing protection. Therefore, this deputy then is in charge of providing the protection to the children. Within this institution, we also have a network of so-called golden protectors of the children's rights, composed of the representatives from the high school, and we have planned to organize an annual conference. We have issued a report, and for 2015 we have planned to undertake a campaign and provide for a bulletin on the realization of this campaign in order to inform the children on their rights and authorizations and the authorizations of the protector of their rights in order to promote for their full protection. Thank you, Mrs. Blanca. Now the floor will be given to Mr. Miloš Vukčević from the Ministry of the Interior, who is the Deputy of the Minister. So good afternoon, everybody. Since I have been introduced by the head of our delegation, I will just say that I'm pleased to be here, and I have noted down 4 questions related directly to the police director, that's to say the Ministry of the Interior, with reference to the training undertaken at the police academy. I'm sorry if the impression had been that those are just general trainings when it comes to the Covenant on Civic and Human Rights, or the human rights in general. I have to say that we pay a great attention to the human rights, not only when it comes to the trainings, but to the detention as well, whereby the drafting the law and the bylaws actually is to a great extent dedicated to the human rights legal system, probably even more than to the security itself. We do pay a lot of attention to the security, but I'm positive that in Montenegro more attention is given to the protection of the human rights of the defendants and detainees, probably rather than to the very fight against corruption and organized crime and security with relation to them. But within the general curricula for the police officers, we have the 43 classes dedicated to the protection of the human rights, ethics, and preventing of any inhuman attitude. And we have also classes dedicated to this covenant. And this year we have started with the trainings of the police officers when it comes to the recommendation given by the EU Commission and referring to the prevention of torture or inhuman behavior towards them or treatment, and we are actually very much dedicated to applying those measures when it comes to the freedom and rights of the detainees. With reference to the issues regarding the torture and mistreatment, especially when it comes to the Roma population, we didn't give any answer because we have not had a single case of the torture or mistreating of the members of the Roma population. We had one case in 2008 where the internal control found it as the case which was not adequately paced in terms that there wasn't supporting evidence. And when it comes to the mistreatment or the torture by the police officers, in 2013, 23 police officers were suspended because the criminal proceedings were initiated against them. They have the defendant status for the misuse of their official duty from the Article 216 from the Criminal Code of Montenegro, and they are suspended until the final verdict is reached. And within the Ministry of the Interior, we have a disciplinary committee as of 2012 until 2014. We had cases where the disciplinary procedures were initiated in 2014. We had them against 4 police officers for severe misuse of the official duty or stepping behind their official authorities, and they have been fined for 36 amounts of their income for this, and it is provisioned that they will be made redundant if there is a final verdict on the case where he or she had violated the official duty. And we have this against...
Dakle, jeste sve. Prestanka radnog odnosa policijskih službenika.
So we had 8 cases where police officers were fired because of the criminal offense abuse of their position. So when we speak about the third issue, how many persons who were detained are acquainted with their rights, we have to say that in this case, and our law obliges us and the police officers to regularly perform their duties and our duties, so that we acquaint the detainees in the language that they understand, Montenegrin or other, on the reasons why they were detained, that they had the right to take a lawyer. Also, they can inform a person who they want to inform, and the diplomatic representative of the country from their country of origin, and also the information list which is being provided to detained person. And this simple list lists all of the rights of the person being detained, and is translated into 6 different languages, including the Roma language, having in mind the issue of Roma population in Montenegro. So I'm not being biased, and I confront this with the words of the NGO Civic Alliance. So with this NGO Civic Alliance and the Supreme State Prosecutor's Office, we have signed an agreement on cooperation, and as a result we organize monitoring, which was being done by the employees of the NGO Civic Alliance with the people who were detained up until 48 hours. And when the court determines that a person should be detained for 48 hours, and they visited all of our premises for detention, And they concluded at page 14 that at the highest level we have a functional system of providing information on the rights of detainees as well as on the procedures which refer to the protection of health of detained persons. Meaning that the police officers inform all of the detainees on their rights as well on the right on medical protection and aid. And this report can be found at the website of the Civic Alliance. So monitoring was done for the detained persons from July 2014 up until December 2013 to December 2013. So from the middle up until the end of last year. Concerning the fourth issue, this is cooperation with NGOs. There is a law on NGOs in Montenegro, which was and we have the rule book on the cooperation of state bodies with NGOs and rule book on public discussions when it comes to the adoption of the laws. And I have to say that there's almost no work group when it comes to drafting of new laws that does not have at least one member of NGO as a representative there, and the rulebook says that it is mandatory and the participants from NGOs are active when it comes to the work of the work groups. They have their representatives in different bodies and commissions like the Commission for Child Rights, Council for Discrimination, Council for Human Rights, so they are actively participating. And also they participated in the drafting of this initial report. I have to highlight that Montenegro is one of the 46 countries which is the joint partner to the Partnership of Open Doors, which was initiated by the US President Barack Obama. I think that I trained all of the issues. I would like to thank you for your attention. Thank you, Miloš. Maybe I would like to say something about the detention system concerning the detainees. Simply just to inform you that in Montenegro there is the Institute for Enforcement of Penal Sanctions, and it has 4 organizational units. This is the investigatory jail in Podgorica and Bilo Polje. We have 321 detainees, and in total we have penal correctional facility where we have prison sentences between 6 months and 20 years, up to actually 40 years, and we have 762 persons there serving their sentence. Concerning what my colleague Miller said concerning the detention, we in the detention, the Supreme Court is performing the monitoring of work of these remand prisons, and the Supreme Court submit biannual reports to the Ministry of Justice on that monitoring process. Also, there is a rule book on the enforcement, and the supervision is being done by the authorized person working in the Ministry of Justice according to the complaints of the detained persons and imprisoned persons. But just to clarify, they have the right to report to eventual cases of abuse in the institutions for serving prison sentences and detention sentences through using mailboxes which were installed in all of these facilities, as well through the representatives of government bodies and NGO sectors. You mentioned that we should work more with the NGOs, and I can confirm, and it was duly noted by NGOs as well, Action for Human Rights, Civic Alliance, For Life, these NGOs, including Juventus as well, they are working in this detention system. They have open doors. They can enter the facilities, organize interviews with the detainees and sentenced people, and they help us and me as well to discover certain facts and act in cases that we are not informed of, some cases of abuse of power or some other things that are not in accordance with the law and procedures. We have been working with them for 2 years already, and concerning the Civic Alliance, we organize the security personnel trainings together with them, so in cases where they have to use force or when there is a fight among the detainees, we have a strategy according to which one should proceed and act if there is a conflict among the detainees or imprisoned persons. And the experts from Germany and the Netherlands reported that the torture in our prisons does not exist. We had one case in 2006 before we gained independence, but actually there is no actual torture in our prisons. This is why I said that we installed mailboxes in cooperation with the ombudsman, and the ombudsperson, according to the law on the protector of human rights and freedoms, can come unannounced with no announcement at all, and you will have to admit that this is a significant information. He can come unannounced and have an interview with the detainees and with the convicted persons. So I couldn't speak for a long while now, but we will have the time to speak and discuss these issues together, so I can provide with detailed information tomorrow as well. We have some 20 more minutes, but I believe that my colleagues succeeded in answering to a lot of your questions that you raised. In cases that you did not receive the answer, we will submit the answer in written. Thank you very much.
Thank you very much, Madam Deputy Minister. Any follow-up questions from colleagues? If there are Mr. Vatslashvili, you have the floor.
Thank you very much, Mr. Chair. Actually, a brief question regarding the Ombudsman. I think in the replies to the list of issues, it has been stated that the new provisions have been introduced providing permanent protection of persons employed in the institution of protector against any sanctions on adverse consequences. Of course, I've consulted the English. I'm sorry I have probably should have started with thanking the delegation for the information provided, which I indeed find very useful. Let me just focus on the question on the issues or information which I would like to receive in addition. So I've consulted the English version of the law, which is available on the online, and obviously it's quite a lot of information, useful information available online. But as I mentioned, I'm not sure if this version was updated, because Article 12 of the law stipulates that protector may not be held responsible for the recommendations and so far and so far. But there is no mention of the immunity of the employees. So I just only try to understand the meaning of the words any sanctions or adverse consequences that the employees could potentially suffer on the basis of expressed opinions and recommendations that they make. And also I would appreciate information about the report contains no information on no statistics actually on the cases investigated by the ombudsman. I would appreciate the number of cases that successfully investigated by the ombudsman, as well as number of initiatives, as I mentioned earlier, to harmonize the legislation with international standards and the Constitution of Montenegro. Thank you very much.
Thank you, Mr. Vatslashvili. The next speaker is Mr. Shani. Mr. Shani, no. Señor Rodríguez Recia tiene la palabra. Perdón.
Muchas
Thank you very much, Mr. Chairman.
Hvala vam velika, predsjedavajući.
gracias de la delegación que han hecho una excelente
Thank you to the delegation for their replies to all our questions. I would like to return to one question that wasn't fully responded to, relating to the obligation of the state to bring its domestic legislation into line with the American Convention 2.2 in the context of Article 8 of the Covenant. It's not clear as to combating discrimination for different reasons, other than those listed: gender, nationality, but it is expressly required to mention racial discrimination, particularly since you've just explained to us that the state ratified the United Nations Convention against Racial Discrimination. So my question is, what possibility is there that it would be possible to suggest that Article 8 be adapted to make a clearer prohibition on racial discrimination and other forms of discrimination? Thank you.
Gracias a usted, señor.
Thank you, Mr. Rodriguez Recia.
No other requests for follow-up. Maybe I could just ask one, perhaps addressed to Judge Kojovic. And this is a question about the Bukovica case. According to information we have, the reason that case fell through was because it was held that the crimes for which with which the accused were charged were not crimes at the time of the offences. These were crimes against humanity. Have I understood that correctly? And if so, was the court's attention drawn to Article 15 of our covenant, which reflects general international law, which of course recognizes the importance of non-retroactivity of criminal law and punishment, the principle of nulla pena sine lege, nulla crimen sine lege. But it says in paragraph 2, nothing in this article shall prejudice the trial and punishment of any person for any act or omission which at the time when it was committed was criminal according to the general principles of law recognized by the community of nations. If I have understood correctly, I'd be very interested in understanding how the court reconciled its own conclusion with the state parties' obligations under Article 15 of this covenant, which is part of the law of Montenegro. And with that, I turn the floor back to the delegation.
Thank you, Mr. Chairman. Before I give the floor to Mr. Radovan Kojovic, Judge of the Supreme Court, I would like to say something briefly concerning the issue of protector of human rights and freedoms. The fact that we did not submit the information on the cases is precisely because the Ombudsperson each year, once a month, submits a report to the Parliament of Montenegro, and all of the cases which were noted in the reports can be found at the website. So annual reports can be found at the website of this institution. I'm sorry that the representative of the Ombudsman is not present, but we have the data and we studied the law on the protection of human rights and freedoms very well. But now, Mr. Kojevic, please take the floor. So when speaking about the Bukovica case, just to understand each other well, so the Supreme State prosecutors in Bielopolje accused the persons for criminal offense, crime against humanity, from Article 427 of the Criminal Code, referred to the European Convention article, Convention on Human Rights. After the first instance procedure, the Supreme Court, the High Court of Bielopolje acquitted these persons because there was no evidence that they have committed the criminal offense in question. Based on the appeals, the Court of Appeals of Montenegro reinstated the court decision of the first instance court, meaning the High Court in Bielopolje, considering that the act with which the defendants were burdened was not a criminal offense based on the criminal code of Montenegro due to the following reasons. The criminal offense from Article 472 of the Criminal Code is a criminal offense which blanket disposition, and in the indictment it had to be stated that the rules of the international law which the plaintiffs, which the defendants breached, and this meant that the state prosecutor's office had to rely on the same stance, but it was also stated that they broke the rules of the international laws determined by Article 7, Paragraph 2 of the Roma Statute, and the Roma Statute entered into force in 2002 only, which means after the moment where the defendants committed the activities. And the second instance court determined that in concrete case, the provisions of the Roma Statute cannot be used compared to in referral to the Article 472 of the Criminal Code, because it can be referred only with the rules of international law which were determined and ratified up until the moment the defendants committed the alleged criminal offenses. And this was the reason why the Court of Appeals reinstated the first instance court decision. The state prosecutors raised the issue of protection of legality, believing that the Court of Appeals was in breach of the Criminal Procedure Code from the Article 386 paragraph 1 and 380 paragraph 1 of the Criminal Procedure Code of Montenegro, believing that considering that the second instance court decision was not in harmony with the decision, but the Supreme Court found that the second instance court made the right decision when they changed the first instance court decision and acquitted the defendants. And since I'm informed about this court case, there was no evidence that the defendants actually committed the criminal offenses. No evidence which were conclusive. And I don't know whether this is the answer to your question, but this is everything that I have to say concerning the decision-making process of the Montenegrin courts concerning this case.
Izvolite, Blanka.
Dakle, probat ću vrlo...
Blanca, you have the floor. I will speak very briefly. Maybe this is a misunderstanding with reference to the laws that are currently posted on the website, but I state that by the amendments and changes to the law on the Ombudsman, the provision has been introduced which provides for the full protection of all the employees in his institution from any sanctions or potential consequences, negative consequences that they may suffer for any statement or any opinion or any recommendation. The report is submitted to the Parliament and it is adopted at the plenary session, and there are two separate reports. One of them is on the discrimination, the other one is on the torture, that's to say the protection from torture in the closed institutions. As far as the racial discrimination is concerned, the new law which was adopted in April this year on the changes and amendments of the law on the protection against discrimination introduces the new form of discrimination, and that is prohibiting the racial discrimination according to the increased general recommendation on the racial discrimination. There is also a liability provision, that is the imprisonment for the racial discrimination, and the law also contains the hate crime, which reference that the great hate crime considers the hatred and violence against persons for any personal characteristics, xenophobia, anti-Semitism, or any forms of hatred based on intolerance, such as intolerance based on nationalism, discrimination, or any offensive behavior against minorities. By the changes of the Criminal Code, a special aggravating circumstance for the enforcement is if the criminal offense has been done for hatred for the reason of the belonging to any national or minority group based on sexual orientation or any personal characteristics. Thank you. In the end, let me just say that we did not answer as to how many shelters there are, how many of them are financed by the state, how many children's institutions there are in Montenegro, in which way the centers of social work operate, whether the families of the persons with disabilities are visited, and since we do not have representatives of the Ministry of Labor and Social Welfare present with us who could answer these issues because it is within their competence, I would like, if possible, to have the questions, these answers forwarded to you later on in writing.
And that's absolutely consistent with our procedures, and we've come to an end of our allotted time, and we're also up to date with our agenda, so that tomorrow we'll begin with a second cluster of questions which colleagues will put to the State Party in respect of the remaining issues. I think it's 15 to 27 or something, 28, and whatever. And then, of course, the delegation will have the usual pause to concert on its replies and present their replies, and we'll then have the follow-up, and everything's going very nicely. So I meanwhile thank the delegation very much for all its responses, its detailed responses, its very well briefed responses, and just wish them a pleasant evening, since we haven't given them any homework to do, a pleasant evening in Geneva, and look forward to resuming our dialogue tomorrow at 10. So with that, the session is adjourned.